Good morning, everyone. I'm Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, the first thing I want to talk about is actually good news. I know I never start that way recently, but I want to talk about good news. So, on Friday, on Halloween, Department of Labor very quietly announced on their website that the flag system was up and running. And so that was a very pleasant Friday surprise. And so we can now use the online system to file LCAs and prevailing wages and perm applications. And so I wanted to just quickly read the online notice that it says. So the online notice says, quote, "We do anticipate increased requests for stakeholder assistance, and this means some stakeholders may experience longer than normal processing and response times. We apologize for any inconvenience this may cause and appreciate your patience as OFLC transitions back to full operational status." So the way that I read this is that nothing has been processed for a month, no prevailing wages, no LCAs, no perms, and it's going to take them a little while to sort through the cases that have been sitting. Not to mention, I think they are also anticipating a flood of cases coming in the door through flag, so prevailing wages and LCAs. And perms. So some of the perms, I know colleagues have been sending them in via mail because of deadline issues, but prevailing wages and LCAs, I think they're about to be really flooded with those. So I appreciate that they have put a note out there on their website to letting us know that it is going to take them a little bit to get back to us, and processing times may be longer than normal. So I appreciate that. So that is some good news coming out of the Department of Labor, which happened on very quietly on Friday. Not so quietly, that came out was an interim final rule that, with almost no notice, given its effective date, that EAD, employment authorization, documents the auto extension of a timely filed EAD renewal for 540 days. Auto extension is now gone. Like, it's gone as of today. So we didn't really have a whole lot of notice on this. They just announced this. So they're saying it is based on security checks. Even though security checks are done when the initial EAD is done, security checks are done when the renewal is actually adjudicated. They have now just stopped auto renewing. So what that means is, I did a little look-see online for you all, and employment-based EAD extensions are now taking roughly 7 months to process. So if we don't have automatic renewal for 540 days, like we just had, the current processing time is approximately 7 months. We can only file 180 days before the expiration, so that's roughly 6 months. We are currently looking now at a 1-month employment authorization gap for employees. So for my folks in the global mobility world, in the HR world, the folks that are responsible for looking at this and keeping track of these expiration dates inside companies who work very closely with outside counsel like myself, I am now recommending that we file early, file 180 days before the requested start date of that new renewal EAD. Tracking expiration dates, it is vital that we have a process internally inside the company as well as externally. For us as outside counsel, we work very closely to make sure that we are tracking and monitoring EAD expiration dates. As well, if you are an individual that has H or L status, remain on that H or L status for as long as possible, even though a green card application may be in the works. So even though someone may have an adjustment of status filed, they may have an EAD based on that adjustment of status, I have always recommended, I will continue to recommend to continue the H-1B and L-1 status for as long as possible, because of things like this. So if someone is working on their EAD and they're now looking at an employment gap, having an H-1B and an L-1 underlying that green card application cuts down on the employment gap. So keep those things in mind. Now, I also think we're going to have a greater backlog to this, as a result of this new policy, especially if employment-based EADs are currently taking roughly 7 months, and we can only file 6 months out. I would love to be wrong. I would love to be wrong and say that processing is going to be super, super efficient, and that it's going to be under the 6-month mark. We'll see. I would absolutely love to be wrong. I would love to come on here and tell y'all I was wrong, but I don't know that that's going to happen. We'll see. Folks that are not impacted by this, the F1 OPT to F1 STEM OPT is not impacted by this. Nor are the L2s and E2s. Those are dependents of L1s and E1s and 2s. Those dependents have work authorization incident to status. So just because they came in as L and E dependents, they automatically have work authorization. They don't have to apply for an EAD. They certainly can. You don't really need one, but some people like to have that card in hand, but you don't need it. So those are the folks that are not impacted by this. So a little bit of good news at the end. We'll see what this means in sort of real life when the rubber hits the road. I will keep y'all updated. The next thing I want to talk about is the H-1B $100,000 filing fee. So that is still in play. Some folks are starting to see RFEs based on the non-payment of the $100,000. I will keep you updated on that once we get a little bit more sort of concrete information on that. But the folks that have to pay when the $100,000 filing fee for H-1Bs is triggered is when an application is filed after September 21st. So now all of them, we're sitting in November now. So filed, requesting consular notification, port of entry notification, or pre-flight inspection, and the individual is outside of the United States. So folks that are not required to pay the $100,000 fee are anybody that has a previously issued visa. So it's not retroactive. It's not going backward. It's only going forward. So if you have a currently valid visa in your passport, you do not have to. You just come in and out on that valid visa, so you don't have to pay the $100,000 fee when you're re-entering. If you are filing amendment applications and change of status applications and extension applications, and your beneficiary is physically in the U.S. when those are filed, you are not subject to the $100,000 filing fee. So this fee needs to be paid prior to filing, because proof has to be shown within the filing that this $100,000 fee was paid. I've gotten a couple of questions about this fee. This fee is in addition to the regular H-1B filing fees. So this does not take away the other filing fees that we have, that we are so used to paying. So there is an exemption to the $100,000 fee. You must show that the work is in the national interest that the beneficiary will be doing, that no U.S. worker is able to perform those duties, that the individual does not pose a threat to U.S. security, and that payment of the $100,000 would, quote, significantly undermine the interests of the United States. So again, lawsuits have been filed. We are sort of waiting and watching as those wind their way through the system to see if those lawsuits require any changes to this new $100,000 fee. As of right now, the answer is no. So as of right now, the $100,000 fee is still in play. So I will keep you updated on it. But that is all I have for y'all this Monday morning. So I hope you have a great Monday morning and a wonderful rest of your week. And if you need help trying to sort through the $100,000 fee, the the termination of the 540-day EAD expiration, or the fact that Flag is up and running again, feel free to reach out. We're happy to have a conversation with you. And I will chat with you again next Monday. Bye.